Time to read some concepts under product liability. Starting on page 828 of like the 12th edition of Prosser, Wade, and Schwartz Torts, Cases, and Materials. This is part 5 of Products Liability, titled Defendants Other Than Manufacturers. And I'm in part C, no less. Harm other than personal injury. 1. Economic loss resulting from personal injury. Lost wages are common forms of economic loss that result from personal injury to the plaintiff and are recoverable with plaintiff's other losses in a strict liability action. Most jurisdictions also permit loss of consortium claims based on personal injury in products liability cases. See Restatement 3rd of Torts, Products Liability, Section 21, Comments B and C from 1998. 2. Economic loss without personal injury or property damage. Because product liability was developed largely to provide compensation to plaintiffs who suffered personal injury or property damage, its applicability to other types of harm is limited. An action in strict liability does not lie when the product itself simply does not perform as expected. Look into Seeley v. White Motor Company, California case. The judge said that the truck galloped and did not perform properly. Chief Justice Traynor explained, however, that if there was an express warranty, including a relevant misrepresentation regarding the quality of the product, a tort action might be maintained on that basis. The Seeley case has been followed by a majority of courts, including New Jersey, which originally had rejected it. Alloway v. General Marine Industries from Jersey, for example. See also Sapp v. Ford Motor Company from South Carolina, alleging a defect in cruise control which caused a fire that damaged only the truck. There is no tort liability for economic loss rule. The courts of many jurisdictions have been strongly influenced by the United States Supreme Court opinion in the Admiralty case East River SS Corp. v. Transamerica Vol. Inc. Talking about and referring to a section in the book called Pure Economic Loss is usually not recoverable. Now, condom users brought suit against the condom manufacturer seeking recovery of the cost of an unwanted pregnancy. Did the product simply fail to perform as expected, or was there physical harm for which the manufacturer should be strictly liable? C.F. McKelly v. Ansel, Inc. In North Dakota, the court denied a motion to dismiss, finding that Indiana would consider pregnancy to be a harm for the purposes of its product liability statute. Agree. 3. A few courts have recognized an exception to the rule that excludes recovery for pure economic loss when the alleged defect creates an unreasonable risk of injury to persons even though actually was injured. Under those circumstances, economic losses resulting from damage to the product itself may be compensable. And see Vulcan Materials Company v. Drill Tech Incorporated, a Georgia case. Compensation provided for a defective product itself if it fails in a sudden and calamitous manner. But see Lincoln General Insurance Company v. Detroit Diesel Corp., a Tennessee 2009 case where a fire in engine of bus caused damage to bus only, joining majority of jurisdictions in declining to recognize exception for product failure that is part of sudden calamitous event. 4th is the damage to property. Section 402A covers damage to property as well as persons, and most courts have agreed with this extension of strict liability beyond personal injury. And see, for example, Morrow vs. Caloric Appliance Corp., where a defective stove set fire to a house. When the product is itself destroyed by a defect, most courts treat this as an economic loss not recoverable in tort, while some courts treat this as a property loss and allow recovery in strict liability. 5. When the defective product is used in the process of manufacturing another product and that product is ruined as a result, this may be treated as damage to the property and recovery allowed under strict liability. So the owner of a building seeks to recover from asbestos sellers for the cost of abating asbestos insulation from its building. Is this merely the failure of the product to provide safe heat retention, or has other property, the building, been damaged by the asbestos product? 6. When a purchaser, such as a retailer, suffers economic loss or a tort suit brought against him by a party injured by the product, he usually may shift that loss to the manufacturer by way of an indemnity action. Should strict liability apply an indemnity claim against the manufacturer of an alleged defective car brought by the driver who was seeking reimbursement for the damages he paid to an injured passenger? Yes. C. Dixon vs. Chicago and Northwestern Transportation Company. Indemnity was not allowed under Illinois law because the plaintiff driver was not free in the accident. When the manufacturer has sold a retailer bad food and this in turn has driven his customers away, is there a well-aged precedent that would allow recovery? There is one. And see Mazzetti versus Armour and Company in Washington. Now we've moved from Section 5 of Products Liability, titled Defendants Other Than Manufacturers, to 6, Legislation and Products Liability. And reading 1, the Uniform Commercial Code. 2, Restatement 2nd of Torts, Section 402A. 3, Tort Reform. The legislature enters the tort area law arena. And 4, Uniform Product Liability Act. 5, tort reform in the states. And that goes on until 6, tort reform in the first decade of the century, and 7, 2010 and beyond. I think they're making reference to the restatement of third of torts, but anyways, Uniform Commercial Code under the Legislation and Products Liability section. Article 2 of the Uniform Commercial Code, which governs breach of the sale of goods, has been enacted in all states except Louisiana. Common law and statutory breach of warranty have had an important influence on the development of the law of product liability. 2. Restatement 2nd of Torts, Section 402A. Beginning in the late 19th, statutes directly applicable to the tort law were enacted in some jurisdictions. For example, some states enacted Restatement 2nd of Torts A through legislation while it was being adopted judicially in most jurisdictions. 3rd, tort reform. The legislature enters the tort law arena. During the late 1970s, liability insurance premiums shot up dramatically. Convinced that the prime cause of the increase in premiums was shift changes in the substantive law liability in favor of plaintiffs, manufacturers, and other suppliers of products sought relief from the state legislatures. Many states passed comprehensive statutory schemes in an emergency climate to decrease the size and number of recoveries against manufacturers and sellers. Those changes were principally in the areas of statutes, limitation, and repose. The significance of state-of-the-art evidence, the effect of alteration or misuse of the product, and the limitation of strict liability against non-manufacturing sellers. 4th, the Uniform Product Liability Act. The same pressures that led legislatures to change product liability law at the state level also affected the federal government. In 1976, the Ford administration established a federal interagency task force on product liability to study the problem. Chaired by Professor Victor Schwartz, the task force continued into the Carter administration and issued a final report in November 1977. One of the conclusions of that final report was that product liability law would be more stable if, as under the Uniform Commercial Code, there was less variation in the laws of the states. Thus, the Uniform Product Liability Act, UPLA, was offered as a model for state enactment. Some legislators have enacted portions of UPLA modifying its contents. Thus, even in these few states, product liability law has retained its variety. Some courts have used UPLA as a basis for changes in common law. See Prentice v. Yale Manufacturing Co. It also was a predicate for the basic structure of Restatement Third of Torts Product Liability, which is dated 1998 here, and taking a functional as compared to theoretical approach to the subject. 5. Tort law in the states. The next 2 decades saw a shift in the approach away from product liability specific statutes to more broadly applicable tort reform legislation. Those changes were principally in the areas of caps on damages, modification or elimination of joint and several liability, changes in the standards for awarding punitive damages, changes in the collateral source rule, and regulation of attorney contingency fees. In some states, the reform regulation was limited to particular categories of tort liability, such as product liability or medical malpractice. Because many businesses and insurers concluded that the product liability problem could not be solved on a state-by-state basis, federal legislation was introduced that would preempt state tort law in a number of areas. A predicate for federal action is that product liability insurance rates are set nationwide on a state-by-state basis. The factual basis for this rate setting is that on average, over 70% of goods manufactured for this rate manufactured in a particular state are shipped beyond its borders. Therefore, legislative product liability action in one state can only provide predictability for a limited number of cases for businesses in that state. Proponents of federal legislation argued that product manufacturers need uniform rules to do business in interstate commerce so that rights and obligations with respect to the same product would not vary simply because a person was injured in one state or another. While many in Congress agreed that there was a clear basis for federal product liability law, there was considerable controversy about the substance of the proposed legislation. Moreover, with each session of Congress, the focus of the legislation, like the reform movement in the states, drifted away from the core of product liability law, establishing the standard for design defects, manufacturing defects, and defects based on failure to warn, into areas of general tort law, such as whether there should be limits or caps on punitive damages and whether the doctrine of joint and several liability should be limited. When the Republicans took over Congress in 1994, an effort was made to expand draft legislation dealing with punitive damages and joint and several liability beyond product liability to all tort claims that arose in interstate commerce. Democratic members found it ironic that Republicans and business groups, usually proponents of state rights, were calling for broad-based federal tort reform, and the effort was doomed. Those who supported product liability reform returned to the concept of a bill that would address only product liability claims. After vetoing a version of a product liability bill, the Clinton administration indicated that it could support federal product liability legislation that did not contain limits on punitive damages or joint and several liability. At that point, proponents of the legislation differed as to whether this limited legislation was worth the effort. With the proponents divided and the opponents united, the movement for federal product liability reform met its end. No general federal product liability legislation has been considered since 1998, and it is unlikely to arise as an issue in the foreseeable future. Limited liability reforms had more success. For example, the General Aviation Revitalization Act, which applies an 18-year statute of repose for general aviation products, was enacted into law in 1994. The C. Schwartz and Lorber, the General Aviation Revitalization Act, how rational civil justice revitalized an industry. And the Biomaterials Assurance Access Act, which limits the liability of suppliers of biomaterials to situations where they had violated contract specifications for their products. This was enacted in 1998. Curiously, those who made these raw materials were not the bill's strongest advocates. Medical device manufacturers and other companies that needed the raw materials argued that they were unable to obtain them because the liability exposure of their suppliers and that the lives and well-being of those who needed the devices were thereby threatened. Tort reform in the first decade of the century. In the beginning, and this is part 6. In the beginning of the new century, the state legislatures remained very active. In 2004 alone, approximately 40 years enacted some form of tort law. Some states included very specific product liability provisions in their tort law reform. Ohio, for example, codified the approach of the Restatement Third of Torts Products Liability from 1998, requiring proof of a practical and technically feasible alternative design. And Ohio Rev Code Section 2317. The Ohio legislation was more than 100 pages in length and covered many other topics in the law of torts, including damages for pain and suffering and punitive damages. Some legislative efforts to limit liability met an end when state Supreme Courts struck them down under provisions of state constitutions such as open courts provisions. From 2005 to 2010, state tort reform efforts slowed down, with the exception of Oklahoma, whose legislature passed a comprehensive tort reform statute in 2009. 23 states enacted some form of the Common Sense Consumption Act, which would protect manufacturers and sellers of food in cases where a plaintiff alleges that eating the food caused obesity or diseases relating to obesity. Butter. The appropriateness of product liability legislations, whether at the state or federal level, is part of a broader issue about who will make America's tort law, courts, or legislatures. Those arguing for more legislative intervention contend that legislators can take a more comprehensive view of the subject, holding hearings to obtain more information and broader views than a court can obtain from lawyers for the adversarial parties in a particular case, and can provide for a prospective application. Those who contend that courts should develop product liability law point to decisions such as those set forth in this casebook. They argue that judges are best suited to handle nuances of law, and that legislators may miss that, and that incremental change can reduce unintended consequences. This debate about who should make product liability law and in general tort law, courts or legislatures will continue throughout your practice. See Chapter 23, Torts in the Age of Statutes. And lastly, 7, 2010 and beyond. In the 21st century, you will be the consumers and manufacturers of products, the attorneys who represent them in litigation and counsel them in risk prevention, and the judges, regulators, and legislators who make the law relating to product liability. How will you change the law? Chapter 16, Nuisance. The term nuisance is surrounded by a great deal of legal confusion. The word itself, which is taken from the French, means nothing more than harm, annoyance, or inconvenience. The courts customarily speak of a nuisance as if it were a type of conduct on the part of the defendant or a condition created by him. Actually, it is neither. The word has reference to a kind of interest invaded, a type of damage or harm. Nuisance is a field of liability rather than a particular tort. Nuisance covers two fields of liability, two distinct kinds of damage or harm. The two have little in common and are unrelated except as each involves the basic idea of causing harm or inconvenience to someone, which is common to all torts. It is only by the accident of historical development that the same word is used to cover the two. But the use of the common term has led the application of much of the same rules to both. Public nuisance. The earliest cases involved pressures, encroachments upon the royal domain or the public highway. An obstruction of the public highway is still a typical public nuisance. The remedy was gradually extended to cover other miscellaneous invasions of the public right. The remedy was exclusively criminal until the 15th century, when it first recognized that a private individual who had suffered special damage could maintain a tort action. In the United States, public nuisances are now very largely covered by statute. There are many types of specific criminal provisions covering such things as black currant plants, buildings where narcotics are sold, or waters where mosquitoes breed. In addition, many states have broad criminal statutes covering public nuisances without attempting to define them, which are construed to include anything that would have been a public nuisance at common law. The Restatement Second of Torts, Section 821, defines public nuisance as an unreasonable interference with a right to the general public, and then provides that circumstances that may sustain a holding that an interference with a public right is reasonable include the following: A, whether the conduct involves a substantial interference with the public health, the public safety, the public peace, the public comfort, or the public convenience; or B, whether the conduct was prescribed by a statute, ordinance, or administrative regulation; or C, whether the conduct is of a continuing nature or has produced a permanent or long-lasting effect, and the actor's knowledge has a substantial detrimental effect upon the public right. So again, public nuisance is an unreasonable interference with the right common to the general public. Okay, where are we? Private nuisance. This form of tort action developed as a reasonable interference with the use or enjoyment of the property interest in land. It is essentially a tort to an owner or possessor of land. It is distinguished from trespass in that it did not require physical entry upon the plaintiff's premises, although it might accompany a trespass. The interference might be with a physical condition of the premises, as by blasting or vibration that damages a house, with the health of the occupant, as by unsanitary conditions on adjoining property, with his comfort or convenience, as by smoke, odors, noise, or heat, or merely with his peace of mind, as in the case of a nearby bawdy house or funeral parlor. A threat of future injury may be treated as a present menace and interference with enjoyment, as in the case of stored explosives, or a vicious dog. Particular conduct may result in both a public and a private nuisance. The plaintiff may then proceed on either ground or both to the extent that she can make out her cause of action. How far must I go to get to another section within nuisance? Bear with me. Not far. Well, let's just talk about defenses, self-help to abate a nuisance, and other torts involving invasion of interest in real property. Before going to defamation. Defenses. When there is an intentional private nuisance, contributory negligence is not a defense, as in the case of other intentional torts. When the nuisance arises out of negligence, most jurisdictions recognize that contributory negligence eliminates or reduces recovery. 3. The dividing line between intent and negligence has led to some difficulty in cases when the defendant has intentionally invaded the rights of the public by creating only a risk of harm to travelers on the highway without the intent to injure the traveler. Some decisions have classified this as intentional and have held that contributory negligence is not defense. These decisions have been criticized. 4. When the nuisance is based on strict liability, contributory negligence of the plaintiff in failing to discover the danger is not a defense. But if he discovers the danger and deliberately proceeds to encounter it, his contributory negligence or his assumption of risk may affect his recovery. Thus, if defendant is blasting in dangerous proximity to a public highway, the plaintiff negligently fails to observe the warning signs, drives past it, and is hurt by a blast, he may recover. But if he sees the sign or a flagman who warns him not to proceed and he insists on doing so, he cannot recover. For a case that deals with this, see Tint v. Sanborn, which is a view of San Francisco obscured by trees on the adjoining property. Self-help to abate a nuisance. The privilege of self-help to abate a nuisance is analogous to the privilege of using reasonable force to protect the possession of land against trespass. Really? It is open only to those to whom the condition is a nuisance. A public nuisance may be abated by a private individual only when it causes or threatens special damage to himself, apart from that to the general public. It is commonly held that the privilege of abating conditions outside the actor's premises depends upon the actual existence of nuisance, and that an honest but mistaken belief will not justify the action. The privilege extends to reasonable force, including the necessities of the situation, and may extend to the destruction of valuable property. It does not extend to unnecessary damage or to damage unreasonable in extent. The actor may not burn down the adjoining house merely because it's used for prostitution. The abatement of a nuisance does not justify the infliction of personal injury or a breach of the peace. Unless the wrongdoer is already aware of and the demand would be futile, the actor, if time permits, must notify the wrongdoer of the existence of the nuisance and demand removal of the condition. An action relating to tree and plant-related nuisances will not lie until the landowner has attempted to self-help, as in cases of overhanging branches, for example, where self-help would cure the nuisance. For an instructive discussion of 4 common approaches to self-help requirements in such cases, see also Restatement 2nd of Torts, section 839 through 40, discussing nuisance with respect to natural and artificial land conditions. The courts have reflected increasing density of population and diminishing agricultural activity in determining if encroaching trees and plants constitute a nuisance. Thus, in Flancher versus Fagella, the court overruled its earlier authority that turned on a finding that a tree or plant was noxious. It rejected also the rule under the restatement, section 839 and 840, turning on the distinction of artificial or natural. Instead, the Supreme Court of Virginia followed a decision in Lane versus W.J. Curry and Sons, which was actually in Tennessee, that found that if self-help were not effective, a tree or plant could constitute an actual nuisance where the branches or roots cause actual harm or pose an imminent danger of actual harm. This is dubbed the Hawaii Rule. Cool. Other torts involving invasion of interest in real property. Besides trespass and nuisance, there are two additional commonly recognized torts arising on behalf of the landowner or possessor of real property because damage to his interest in land. They are interference with the support of land. This applies to both lateral support and subjacent support. If the withdrawal of the support is sufficient to cause a subsistence of the land in its natural condition, for example, naturally necessary support is withdrawn, a liability subject to no showing of fault on the part of the defendant is required. Damage to artificial additions to the land is also included. If the withdrawal of support would not have caused a subsistence of the land in its natural condition, but does cause subsistence because of artificial additions to the land, then liability may still exist, but it depends upon a finding that the actor's conduct was negligent. On subsistence caused by withdrawal of groundwater, see a bunch of cases. And sections 817 through 821 of the Restatement Second of Torts. The second tort involving invasion of interest in real property is the interference with the use of water. This tort covers three types of water: water in a watercourse or lake in or adjoining land, riparian rights, groundwater, sometimes called subterranean water or underground water, and surface waters from precipitation. On the subject of riparian rights, there are three distinct legal theories for the determination of the rights involved. The first, adopted in England and used by a few American states, is the natural flow theory. The right to have the water flow as it was wont to flow in nature, qualified only by the right of each riparian owner to make limited use of it. The second, adopted in a majority of American states, is the reasonable use theory. The right to be free from unreasonable uses that cause harm to the proprietor's own reasonable use. The third, adopted largely in the states of the West, is the prior appropriation rule. That beneficial use of the water is the basis of the right to it, and that priority of use is the basis of division of it between appropriators when there is not enough for all. The reasonable use theory is the most flexible and adaptable one, and it has succeeded in adapting to both of the other two in terms of the factors affecting the determination of when a user is reasonable. It is now distinctly the majority rule. In a number of states, there are statutory provisions modifying the common law rules. On the use of groundwater, subsurface water, there are also several theories. 1. The English rule of absolute ownership. 2. The American rule of reasonable use. And a rule of correlative rights. And third, the rule that an underground stream is like a surface stream. Here too, the adaptable reasonable use rule is growing in a number of adherents, and there are statutory modification in some states. As for surface waters, there is general agreement that a landowner can use as much of them as he wants. The subject is canvassed in Chapter 41 of the Restatement, Section 841 through 864. Defamation. I'm going all the way over this for a very good reason, because it's only 2 pages. The term tort, deriving from the Latin tortus, meaning twisted, is apt for the tort of defamation in 2 senses. The conduct involved is twisted or crooked, and the law governing it is twisted or wrenched sadly out of shape by its historical development. As one commentator put it, the law of defamation was marred in the making. Rules and distinctions originating from ancient controversies over jurisdiction, long since obsolete, nevertheless became frozen and crystallized. Originally, the common law torts took no jurisdiction over any defamation, leaving it to be dealt with by the local seigneurial courts. When these fell into decay, the ecclesiastical courts began to take jurisdiction over slander, regarding it as a sin and punishing it with penance. Since the cases all involved oral defamation, slander became identified with word of mouth. When the ecclesiastical courts in turn began to lose their power, there was, in the 16th century, a slow infiltration of tort actions for slander into the common law courts. The excuse for this invasion of church jurisdiction was that some temporal damage had been done, distinct from the mere spiritual offense, and that it was properly a matter for the king's courts to redress. A long conflict of jurisdiction, part of the broader contest between church and state, finally fixed this as a requirement for any slander action at common law, which is temporal damage. And temporal damage is a pecuniary nature, was proved or could reasonably be assumed. So the result was that slander became actionable only in those cases where special damage of a temporal or pecuniary character was proved or could reasonably be assumed, which I think means monetary. About the beginning of the 17th century, the Court of Star Chamber began independently to punish the crime of libel in order to suppress the seditious publications that had multiplied with the spread of printing. In the earliest cases, the libels were political and the crime was a form of sedition. It was gradually extended to non-political libels, and still later tort damages were awarded to the person defamed, probably in order to provide a legal substitute for a duel when it was forbidden. When the Star Chamber was abolished, jurisdiction over libel in turn passed to the common law courts. Through this process, libel became identified with printed or written defamation, while slander remained oral. Instead of merging the 2 torts, the courts maintained their separate identity as well as the rules that had grown up around slander. In the 16th and 17th centuries, the judges were annoyed by the flood of rather frivolous actions let loose upon them once their jurisdiction over slander was established, and reluctant to extend the possibilities of recovery. In addition, under development law of defamation was arrested when it encountered the rising tide of sentiment in favor of freedom of speech and the press, which, together with the odium attached to the memory of the Star Chamber and its political prosecutions, made any action for defamation an unpopular one, and the court somewhat reluctant in dealing with it. Few commentators have had a kind word to say about the general condition of the common law of defamation as it finally developed. Many calls have been made for its complete overhaul and reform. Some studies have been overtaken with this end in view, but have failed to accomplish any real worthwhile results. The outstanding historical treatment are R. Helmholtz introduction to select cases on defamation to 1600. Selden Society, 1985. In 1964, a new reformer entered the field. The United States Supreme Court decided in a case of New York Times v. Sullivan holding that the free speech and free press provisions of the First Amendment, acting through the 14th Amendment, affected the common law of defamation. Since that time, the decisions under the First Amendment have produced numerous changes in the law of defamation, some of them very far-ranging in effect. The Supreme Court itself is still slowly feeling its way on the course to take. The Court has wavered and changed its position on several matters, so that a good deal of uncertainty remains as to the extent of present law and future change in it. For this reason, the first part of this chapter will be primarily concerned with the common law of defamation and incidental references to constitutional holdings. Beginning with New York Times v. Sullivan, the emphasis will be placed on the constitutional developments. The law of torts involves a careful balancing of conflicting individual and social interests, with the establishment of principles, rules, and standards for the purpose of enabling the court to reach the appropriate result in the particular case. In this chapter, you will observe that the same kind of balancing of interests is followed. Social concepts about the function of reputation have shifted from protection of honor to protection of property. This individual interest has had to be reconciled with the public interest in freedom of expression, not only as developed by the common law, but more recently by dint of the First Amendment. See Post, The Social Foundations of Defamation Law, Reputation, and the Constitution. This maelstrom of interest sometimes creates serious difficulties in maintaining orderly organization in the tort law of defamation. It is stimulating and sometimes frustrating process to contemplate and study. Never once did that introduction give us the definition of defamation. Which is awesome. I would have to say that it's about time to call it, but we will return, have a discussion about libel and slander on page 886. There's like slander per se and libel per se that we might get into, and we totally skipped chapters. The basis of liability for defamation is good. Intro to read. And malice is a section here under the basis of liability. Private plaintiffs, versus public plaintiffs, because defamation just kind of, I guess, started off as being for the protection of freedom of speech against, with regards to politics, which is a public concern. So actually, private came first. Public figures and public officials will be discussed in another recording. And there's privileges to protect free speech and political and public debate, and absolute privilege, conditional or qualified privilege, remedies. Last but not least, remedies goes on forever and ever, which is great. We're skipping privacy, which is chapter 18. We're skipping civil rights, chapter 19. might think to get into that just briefly, since it's a real world concept. And then we skipped right over to the misuse of legal procedure and have yet to really define what that is, but it's coming in the next recording.